Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. Earlier today on the Indie Zone podcast, we reported that Judge Hippler had rendered an order on one of the motions in Limine that's dealt with family members in the courtroom. Because there is so much information in here that deals with a number of different topics, I wanted to get on here on the YouTube channel, show you the actual order, and go over what the court is saying here, the rulings that have been made, what has been reserved in terms of a ruling that will be made after there is an in-camera inspection. It touches on the state's intention to possibly call the Kohberger family members as state witnesses in the case, as well as rendering a ruling for what this motion in Limine was originally for. And it had to do with the state coming forward and looking for an order in Limine before trial, determining whether the family members of the victims could be in the courtroom during the entire trial, whether or not they were going to be testifying. And this is the case in chief, which is scheduled to commence per Judge Hippler's October 9th, 2024 pretrial and trial order, which states, page 1, that voir dire, the process of jury selection, will commence July 30th, with the case in chief scheduled to start August 11th. That's the guilt phase of the trial. I wanted to point out to you that of the remaining 23 or so motions in Limine, most of which deal with evidence that will or will not be permitted to get in front of that jury, those rulings remain pending. The court has not made any rulings on such matters as suspect vehicle 1, IgG DNA, AT&T timing advance records, the stop of Mr. Kohberger in Moscow in August of 2022, body cam image that has never been released, and other related materials. Those written orders remain pending. Turning to the order that the court entered on the 16th of April 2025, it begins. The state requests an order pursuant to Article 1, Section 22(4) of the Idaho Constitution and IC 195306 1B and 3. So what's happening right now? Remember, we have said before that a motion is an application for a court order. So when you read the motions in Limine that were filed on the 21st and 24th of February, whoever was filing the motion, if it was the state or the defense, they were applying for a court order. So here we see the state is citing to legal authority, Idaho Constitution and a statute, allowing immediate family members of the victims to be present during the entire trial, regardless of whether they are scheduled to testify. Attached to the state's motion, Exhibit S in Sam 1, is a list of those individuals the state considers to be immediate families and under the foregoing provisions. It goes on. They are the siblings, parent, grandparents, and step-parents of the victim. Defendant stipulates that the individuals listed in Exhibit S1 may remain in the courtroom during trial. So here we're reminded that the defense had no objection that the victim's family members had a right to be in the courtroom. But what the defense did is they asked for guidance regarding attire, any t-shirts with words on them, things of that nature. And they were concerned that if there were t-shirts that had the names of victims or references to the ultimate penalty, this is a capital case, they wanted instruction regarding what could and could not be appropriate to be worn during the trial, because of the concern of prejudice against Mr. Kohberger if the jury were to see this. The state agrees that the court has discretion to issue rules regarding courtroom decorum, and they cite to McDonald versus Pless, which is a United States Supreme Court case back in 1915. At the appropriate time, the court will exercise its discretion in this regard. So the court is basically saying, I'm not going to rule right now regarding this matter, but if you look and you see footnote number 4, it says here, nonetheless, the parties can rest assured that those attending trial will not be permitted to display in any form or media messages or signs of support or opposition related to the parties or issues in the case. Further, no demonstration or outbursts of any kind will be permitted or tolerated. So the court's basically laying down the law right now, months before trial, that people are expected to dress appropriately. There shouldn't be messages on any t-shirts or clothing or hats that people may wear into the courtroom. And he's also saying that any physical outbursts, signs of emotion from either side will not be tolerated. He expects the court to proceed in to make sure that the jury is not prejudiced and that it doesn't result in a motion for a mistrial. The order continues. However, in his response to the state's motion, defendant requests that his immediate family members, siblings, and parents be allowed in the courtroom, arguing their exclusion, this is Mr. Kohberger's family members, would violate his Sixth Amendment right to a fair trial. So he cites to the Sixth Amendment of the United States Constitution here. The state objects on the grounds that while, and we go on to page number 2, family members of victims have a constitutional and statutory right to attend trial, there is no comparable provision for a defendant's family members. So what they're saying is, the order started out with citations to the Idaho Constitution and to the state statute that give victims' family members the right to be in a courtroom during a trial. They're saying here there is no comparable or similar type of statute or constitutional right as to the defendant's family members. The state also contends that it intends to call members of the defendant's family as witnesses at trial and will ask the court to exclude any testifying witnesses from the courtroom pursuant to IRE 615. This is an Idaho rule of evidence. And this is where sometimes during trial you'll see one of the members of either the defense, the prosecution team stand up and say, I'm invoking the rule, Judge. And that is shorthand for Judge. Anybody who's in the courtroom who's going to be testifying, please have them leave because they don't want them to hear what other witnesses are testifying. That's basically the reason why the rule is invoked in that manner. Going on to the next paragraph, the court here cites to United States Supreme Court case law, which recognizes that the right to a public trial afforded by the Sixth Amendment entitles a criminal defendant, quote, at the very least to have his friends, relatives, and counsel present no matter with what offense he may be charged, citing to In re Oliver. This is a 1948 U.S. Supreme Court case. So basically what the court is saying here, sorry state, there is a comparable right. It is found in the U.S. Supreme Court's understanding and interpretation of the Sixth Amendment to the United States Constitution. The court goes on to cite further federal law here, in that Judge Hippler states courts recognize that having a defendant's family members present at trial advances the value served by the right to a public trial, i.e. ensuring fair proceedings, reminding the prosecutor and judge of their grave concerns, discouraging perjury, and encouraging witnesses to come forward, and citing to U.S. versus Rivera. This is a Ninth Circuit appellate case from 2012. So the court's basically finding case law that stands for this proposition in a way as it relates to having Mr. Kohberger's family members in the courtroom. But Caveat being, like other constitutional rights, a defendant's right to a public trial is not absolute. The right to an open trial may give way to certain cases to other rights or interests. Here, he's finding that there is an overriding issue here. If the Kohberger family is going to be called to testify, then the Idaho rule here does allow them to be excluded by invoking the rule until such time that they are called to the stand. And then after that, they can be free to sit in the courtroom if they wish. The judge then says, while the court is sensitive to the state's concerns about allowing testifying witnesses present during trial, the court is also sensitive to the fact that this is anticipated to be a lengthy trial and that the defendant would like the support of his family. The court, in the October 9th, 2024 order, guesstimated that this trial would go through November 7th of 2025, approximately 3 months. It may go longer. There's really no way, ladies and gentlemen, in my opinion, to say with certainty that the trial is going to go from the 11th of August to November 7th. Things may happen. There may be matters that go on longer than anticipated. The trial could be longer than that. But in any event, 3-month trial. He wants his family members with him. There's a footnote here stating, in addition, the court understands and empathizes with the concerns that parents themselves, having done nothing wrong, would have, and the trauma that they would endure because of a child being accused of and tried in a capital case, and their desire to be present for their child. Further, the scope of his family members' testimony is likely going to be limited in an effort to reach a solution that upholds the rights of both parties. That's the state as well as the defense. The court now is coming up with a solution. The court will require the state to submit for an ex parte, in-camera evaluation, the reasons why they are wanting to call the Kohberger family. A list of the Kohberger family members that intends to call a trial and the purpose for calling each of them. State must also identify why each family member cannot be called very early in its case in chief and articulate why exclusions of the family member is necessary under IRE 615, particularly given the unprecedented publicity of the case, which has made much of the evidence available to those who wish to know. The state must submit these materials no later than April 25th, 2025. The court will provide the parties with its decision at or before the pretrial conference on May 15th, 2025. For now, the motion is granted as to the victim's family, to the victim's family members that are on that list that was submitted to the court will be permitted to be in the courtroom during the entire trial, whether or not they're being called to give testimony in conformance with the statute and what the Idaho Constitution says. As to the defendant's family, it's reserved, so he's not making a ruling right now. He's going to wait until after he receives these ex parte. That means one side only is giving the judge this information. Then the court's going to in camera. That means for the judge's eyes only. So we're going to see probably a filing by the state on or before the 25th of April saying that they are providing under seal this information in compliance with this court's order. And then thereafter, we'll see a written order before or possibly at the time of the final pretrial conference, which is scheduled to occur on May 15th, 2025. So we will continue to monitor this situation for you, and when the other orders on the in limine motions are filed, we will, of course, let you know. This is Kathy. Thanks for joining us here today.